extent should someone with an intellectual disability be held as legally responsible as someone without one, even considering the death penalty? This is Coffee Over Court, and today we'll be discussing the landmark case of Atkins versus Virginia, a case that challenged whether individuals with intellectual deficiencies should be held to the same legal standard as those without. The case ultimately reshaped the law by eliminating the death penalty as a possible punishment for individuals with intellectual disabilities.
We'll be analysing the whole case, breaking down the backstory, and the final court ruling, but first...
Today's drink is a wood oak cappuccino.
Let's try
Taste
it.
test. Interesting.
Tastes
Okay.
like cappuccino.
Let's dive right in.
In York County, Virginia, on August the 16th, 1996, 18-year-old Dale
Renard
Atkins and his accomplice, William Jones, were involved in the murder of 21-year-old Eric Nisbet. After spending a full day together, drinking alcohol and smoking marijuana, Atkins and Jones approached Nisbet outside a nearby convenience store, where they attempted to rob him. After realizing he only had $60, they abducted him and forced him onto his vehicle to drive to a nearby ATM, where footage from a surveillance camera showed them forcing him to withdraw $200. The two abductors then drove Nisbet to a secluded area where he was shot 8 times and killed.
After the murder, police investigated the case and arrested Atkins and Jones. During questioning, Atkins admitted to his involvement in the crime, but his account conflicted with Jones' statement. This is because Jones accepted a plea agreement and testified against Atkins, claiming Atkins was the one who committed the murder. This means Jones avoided the death penalty and instead received life imprisonment. During the trial, the jury largely relied on Jones' version of events, as they were more coherent and credible, ultimately leading to Atkins being convicted of capital murder.
Because this crime was eligible for the death penalty, the case moved into a sentencing phase. During this stage, forensic psychologist Evan Nelson testified that Atkins was in the range of being intellectually challenged. His opinion was informed by interviews with those who knew Atkins, review of school and court records, and the administration of the Wechsler Adult Intelligence Scale, which showed Atkins had an IQ of 59 and had significant cognitive limitations. Despite hearing this testimony, he still sentenced Atkins to death. Before we continue, let's discuss why Nelson's argument about Atkins' low IQ was significant.
In legal terms, deterrence value refers to the effectiveness of the threat of legal punishment in preventing an individual from committing an illegal action. Reduced deterrence value refers to a relatively low ability for the offended to weigh future consequences against present actions, meaning they are more likely to commit a crime. Deterrence value is usually based on 3 factors. 1. Certainty of the punishment. This refers to the likelihood of being caught and punished for this crime. 2. Severity of the punishment. This refers to the degree of consequence for committing the crime. And lastly, celerity of the punishment. This refers to the speed at which offenders are punished following the offense. Someone with an intellectual disability may have low deterrence value because their cognitive impairments means they can't accurately rationalize with these 3 factors, so they perceive these factors as low. Also, people with intellectual disabilities may have increased vulnerability. Intellectual disabilities can impair reasoning, judgment, impulse control, and consequence understanding, and they could also have reduced level of moral culpability. Thus, they can still be held legally responsible for their crimes, but they are considered less blameworthy than someone without such impairments.
In 1999, Atkins' lawyers appealed the death penalty decision to the Supreme Court of Virginia, where his conviction was upheld. But his death sentence was reversed on appeal, finding the verdict form has not included an option for the jury to impose a life sentence, but the conviction remains valid. The verdict form, where the jury is meant to formally document the decision, was misleading because it omitted a crucial line about how Virginia's law allows juries to give mercy and give a life sentence instead of a death penalty. The jury was essentially blinded from the alternative option, so the court had to acknowledge that we would actually never know if the judge would have ruled differently with the alternative option available.
At the second sentencing hearing, psychologist Stanton Samnow testified that Atkins was at least of average intelligence, after assessing his vocabulary and knowledge of current events, and testified he understood cause and effect and could use relatively complex words. He did acknowledge Atkins' lag in academic performance, though. The prosecution also presented testimony about Atkins' criminal history, which began in early adolescence and included over a dozen prior felony convictions for robbery, larceny, and burglary.
Thus, Atkins was sentenced to death a second time, and Atkins' team did appeal in 2000 to the Supreme Court of Virginia for a second time, but once again the death penalty sentence was upheld.
Then in 2002, Atkins' team appealed to the highest court in the US, the US Supreme Court, which granted certiorari, meaning they agreed to hear the case and review the lower court's decision. This is because several judges had raised serious concerns about the constitutionality of executing individuals with intellectual disabilities. Additionally, by the time Atkins had reached the US Supreme Court, a growing number of states had already banned or restricted the practice of executing people with intellectual disabilities. In fact, in 1986, Georgia became the first state to implement this law, with 16 more states following the next 12 years. Claire, will you expand more on the constitutional concerns raised?
Yep. So, there was basically a big controversy about violating the 8th Amendment here, which the 8th Amendment basically states that it should be protecting individuals from being subjected to excessive bail, excessive fines, or cruel and unusual punishments. Now, the debate lies here on the fact that Atkins had a significantly low IQ, and hence there was a limited capacity to understand or foresee matters, which is different from other criminals with a full adult capacity to understand things. Also, like Eliza just talked about, there was also some controversy about moral progression and trends because there was essentially an evolving standard of decency across the US, with Georgia also banning death penalties against intellectually challenged people. And so because many states were already doing that, Virginia also felt the need to follow that trend. Moreover, I think it's important to talk about criminal culpability because to be able to punish one legally, you have to establish 1, mens rea, 2, actus reus. In the case of Atkins, we know that the actus reus is there and that was established, but mens rea is the one that's hard to establish clearly because he is mentally impaired. He is intellectually challenged, so it's hard to actually establish the mind of it. And another thing I also want to talk about is the purpose of death penalties, because essentially it is to be able to give the greatest possible punishment that exists and deter populations from committing similar things, and I guess also applying the principle of lex talionis, or eye for an eye. But the argument here is that it's not necessarily effective if the criminal can't rationally process such punishments and understand or reflect on their act meaningfully because they are mentally challenged. But also another thing to talk about here is that this dilemma or this controversy is very layered, right? There's also a moral dilemma with victims as well, because victims and their family, this decision can be very controversial because sometimes we have to talk about how IQ scores and their boundaries can be blurry or subjective. And there's also very big ethical concerns about the vileness of Atkins's crimes, because the argument there is that essentially the malice would have still existed either way. So is it actually right to give him mercy if he had that bad intention nonetheless? And so victims still had that psychological distress of not feeling like they're doing the most that they can to punish their perpetrator.
So, in a 6-3 decision, the court ruled that the executions of individuals with an intellectual disability is a cruel and unusual punishment, as prohibited under the 8th Amendment, stating that the execution of mentally disabled criminals will not measurably advance the purpose of the death penalty. Justice John Paul Stevens, representing the majority, noted that capital punishment should not be indicited for defendants with an intellectual disability, because of the high possibility of false confessions, less ability to present evidence in their defense, decreased efficacy in working with their attorney in their defense, difficulty responding to questions when taking the stand, and the possibility that others involved in court proceeding will misjudge the defendant's intellectual functioning for callousness. Atkins' death sentence was overturned on ruling that executing people with intellectual disabilities violated the Eighth Amendment, and he was sentenced to life imprisonment instead.
After this, there was a constitutional ban on the death penalty of individuals with intellectual disabilities in the United States. It was already banned in some states, like we've talked about, but this case is what led it to become nationwide. It also raised awareness of the importance of forensic psychology in legal decisions.
And guess what? In 2005, Virginia prosecutors attempted to retry Atkins for the death penalty, but the jury did not impose this.
Thank you for staying with us till the end.
Coffee over court out.